Okay, beautiful morning to you, and glad to have you join us on your highly conversational show, Frontline, where we bring you insightful analysis, balanced perspective, and meaningful conversations on issues shaping Nigeria. Olakunle Balogun is my name, and welcome to today's edition of Frontline. Well, today promises to be another significant day when you talk about the national scene. This is as the National Security Advisor, the Attorney General of the Federation and Minister of Justice, the Accountant General of the Federation, the Minister of Foreign Affairs, and several top government officials are expected to appear before the House of Representatives ad hoc committee investigating the legal basis, operations, funding, and budgetary inclusion of the controversial Presidential Foreign Investment Promotion Council, PFIPC. Well, the probe is expected to shed more light on questions surrounding transparency, accountability, and compliance with constitutional and financial regulations. Well, in another development, the United States President Donald Trump has commended President Bola Ahmed Tinubu for what he described as his decisive leadership in confronting terrorism and insecurity in Nigeria, particularly attacks on Christian communities. The commendation contained in a letter dated July 6, 2026 and made public by the presidency yesterday has sparked discussions about Nigeria's security efforts and the growing international recognition of its counter-terrorism activities. Meanwhile, the Independent Corrupt Practices and Other Related Offences Commission, ICPC, has uncovered 908 ghost workers across several federal ministry, departments, and agencies in what investigators describe as a massive payroll fraud. The commission says it has recovered about 942 million naira in fraudulent salary payments, with the Nigerian police force and 5 federal agencies recording the highest number of suspected fictitious employees. Well, the revelation, once again, raised serious questions about accountability in the management of public funds. Well, our attention this morning, however, turns to 2 issues that strike the heart of justice, national security, and the fight against corruption. First, we examine the Ansaru verdict: justice delivered or sentenced to lenient. Following the Federal High Court's decision to sentence 2 top Ansaru commanders to life imprisonment after they pleaded guilty to terrorism-related charges, the verdict has ignited nationwide debate. Should a guilty plea reduce punishment in terrorism trials? Does life imprisonment, adequately reflect the gravity of terrorism, or should the court have imposed the maximum penalty available under the law? Well, we will also discuss the House of Representatives' decision to investigate all seized, forfeited, recovered, and repatriated assets managed by government institutions since Nigeria returned to democracy in 1999, with recovered assets estimated to be worth trillions of naira. Can Nigeria finally account for its anti-corruption gains? As the Proceeds of Crimes Recovery and Management Act 2022 achieve its purpose, and what reforms are needed to ensure transparency and accountability? Well, this morning, guiding us through this critical legal and also policy issue is Dr. Wahab Shittu, SANs. Well, he is a distinguished senior advocate of Nigeria, lecturer in the Department of Jurisprudence and International Law, Faculty of Law, University of Lagos, and is also one of Nigeria's foremost experts on criminal justice, anti-corruption, and asset recovery. Well, he has served as the lead external prosecutor to the Economic and Financial Crimes Commission, EFCC, since its inception, and he has also prosecuted cases on behalf of the ICPC as well. That's the Independent Corrupt Practices and Other Related Offences Commission. So stay with us as we unpack the legal implications of this landmark development and what they mean for Nigeria judicial system, national security, and the fight against corruption. Once again, I am Olakunle Balogun, welcoming you to the Thursday edition of Frontline. Let's take a quick break. We'll return shortly.
Unlock uninterrupted freedom to work, play, and connect. At iWorld Networks, we deliver super fast, unlimited internet that is 6 times faster than the competition. Whether you are working from home, running a business, or streaming your favorite shows, we have got you covered with reliable internet and 24/7 customer support. Ready to experience seamless connectivity? Join the iWorld Networks family today. Get started. Call Titilade at +234 813 152 9077 or visit iwn.nj. iWorld Networks, connecting possibilities.
You think you've got eyes, nose, and ears for news? Then the Eyewitness Report feature on the Eagle FM 102.5 app is made just for you. Simply download the Eagle FM 102.5 app on Google Play Store to get started today.
Hello.
Eagle 102.5 FM, up there with you.
Good news for eligible Nigerian citizens. The ongoing continuous voter registration exercise has been extended to Sunday, the 26th of July, 2026, giving you more time to register.
The easiest part, starting from Wednesday, 8th July, you can start and complete your registration online using your phones, tablets, or smart devices.
Your fingerprint and photograph can now be captured online. Just visit cvr.inecnigeria.org to register.
Remember, the physical registration option is still available at all INEC states, local government offices, and designated centers.
No more excuses. Don't wait till the last minute. Register today.
This message is brought to you by the Independent National Electoral Commission, INEC, making your vote count, consolidating our democracy.
Yeah, man.
Yo. You can now listen to your favorite shows on the go and wherever you are.
You serious?
Plus, you get to explore other exciting features when you download the Eagle FM 102.5 app on Google Play Store today. So what are you waiting for?
Place to your workplace. Long-term benefits of place have been proved by scientists.
Eagle 102.5 FM.
Up there with you.
Okay, beautiful morning to you again. This is Frontline on Eagle 102.5 FM. This is where we take our time to help clarify issues of public interest across the socio-economic and political spectrum. Olakunle Balogun is my name. And like I said earlier, our attention is on two issues that have struck the heart of justice, national security, and the fight against corruption. First on the show, we will examine the Ansaru verdict, justice delivered, or too lenient. This is following the Federal High Court decision to sentence 2 top Ansaru commanders to life imprisonment after they pleaded guilty to terrorism-related charges. Well, to guide us through the critical legal and policy issues on the show this morning is Dr. Wahab Shittu, SAN, a distinguished senior advocate of Nigeria, lecturer in the Department of Jurisprudence and International Law, Faculty of Law, University of Lagos, and one of Nigeria's foremost experts on criminal justice, anti-corruption, asset recovery, and he has also served as the lead external prosecutor for the Economic and Financial Crimes EFCC, and also the another anti-graft agency, that is the Independent Corrupt Practices and Other Related Offences Commission, ICPC. Dr. Wahab Shittu, Senior Advocate of Nigeria, is our guest this morning. Dr. Shittu, good morning to you. Glad to have you join us on Frontline this morning.
Good morning, and thank you for inviting me to comment on pressing national issues.
Well, good to have you join us on the show this morning. But in order to set the context for our conversation this morning, looking at Nigeria's current state, how would you assess the role of the legal system in Nigeria in addressing the country's biggest challenges, from terrorism and insecurity and corruption and public accountability? Let's set the template for the conversation.
Well, I'm sure you are aware that our judiciary is perhaps the best, not only in Africa, but in the Commonwealth. Our judges are doing their best to ensure that we combat corruption and terrorism, as well as enhance the quality of administration of justice generally in the country. When I say this, I'm not saying that we don't have challenges. There are challenges that we are trying to surmount, but I think it will be a disservice to our stellar judicial officers to say that we are not doing enough. They are trying their best, and I think about their best, there's still room for improvement, and it's work in progress.
Interesting. There's always room for improvement. But let's begin the conversation with the Ansaru verdict. Justice delivered or sentenced to lenient? Recently, the Federal High Court sentenced 2 top Ansaru commanders to life imprisonment. Reports have it that it was after they pleaded guilty to terrorism charges. I like to have your view, from a legal standpoint. Do you believe the judgment delivered justice? Looking at the charges against them, the Kuje attack, the army barracks in Wawa, Niger State, and also the link to them regarding the abduction of students in Orire, leading to the beheading of the teacher as well, because reports have it that one of the demand of the Orire abductors was that, their commanders should be released as well. And that has also been linked to these 2 Ansaru commanders. And to now say the Federal High Court just given, a life imprisonment. Your say on this. Is justice said?
Thank you very much. We all agree that terrorism is a crime against humanity. It's not just a local crime, it's a crime against humanity, involving the destruction of lives, destruction of property, destruction of the economies of nations, as well as destruction of critical infrastructure. It is a very, very serious crime that ought to attract maximum, penalty for those found to have perpetrated the offenses. So, I I will say that whether justice is delivered or the sentence is too lenient in the particular situation you have referenced is a question of perspective. And I will explain.
Okay.
First, it can be said that the judicial option is preferred to prolong an indefinite, detention. Many of these terrorists have been in detention for years, some of them for months, without trial. But I think now that the judiciary has intervened and there's a trial going on, we must first of all salute the current Attorney General of the Federation, Mr. Latif Fagbemi, SCN, for his determination to ensure that these terrorist suspects are brought to trial. It is really unprecedented what is going on here. You see that the judiciary has intervened and putting these people to trial. And there have been, in the particular case we have referenced, the suspects have been sentenced to life imprisonment. That is a salutary development. It shows that as a nation, we are acting in difference to the rule of law, and that we have an Attorney General who understands the elements and the rudiments of rule of law. And our judges are really determined, because we have designated judges by the Federal High Court who are, earmarked to handle some of these cases. That, in my view, shows capacity of the judiciary to handle some of these cases. To that extent, the fact that the judiciary is handling some of these cases, and they have handed down life imprisonment in the particular case you have referenced, shows that the system is working. It shows that the judiciary respects the rule of law. But in spite of what I've said, there are some concerns that we must raise about the trials, in spite of the fact that, okay, first, they are concerned whether fair trial is even guaranteed in the particular circumstances of not only the subject matter of reference, but generally in the trial of this. Because we want to be sure that whoever is put to trial is given fair trial. The Human Rights Watch has expressed some, concerns. For instance, they have criticized mode of the trials. They say that the trials were conducted sometimes without witnesses or circumstantial evidence. Some have also said some of these defendants may have been forced to plead guilty because most of them don't plead guilty to the charges. They show that, and that maybe some of them may have been coerced. And they have also been concerned that the defense available to this suspect may have been inadequate. The Human Rights Watch also referenced inadequate judicial safeguards. It's also argued that suspects who provide material support dominate the docket. The real offenders who are responsible for these international crimes are not being prioritized. And so generally there is need for statutory investment in forensic capacity, in digital evidence, in witness protection, and prosecutable intelligence. As to the question whether this is sufficient, whether the sentences meted to the suspects are sufficient or deterrence, I would say it do appear that arms suppliers and financiers appear to be the targets of these sentences. 25 years concurrent time for arms suppliers and financiers and all that. The real people on the field who ought to be, not to book, have not been prioritized. And that is that cause for a lot of concern. So what I'm saying generally is that anyone with due adherence to human rights standards ought to be executed. Because terrorism Terrorists target lives, they target critical infrastructure, they target destructions of the economy. So we should be unsparing. in the treatment we give to them, provided there are safeguards, sufficient safeguards for fair hearing, sufficient safeguards for human rights, standards, and fair hearing is also guaranteed that they have access to quality counsel, and that they have sufficient, facilities to defend themselves. If fair trial is guaranteed, if human rights is respected, then they should get the maximum punishment for bringing humanity to ruin by their actions and
Okay.
So I would say whether the sentence is
Dr. Wahab, I need you to speak closer to your microphone.
What I'm saying is that whether the sentence is sufficient deterrence or not is a question of perspective. It depends on whether fair hearing is delivered to the suspects, whether fundamental rights are respected in the trial of the suspects. If all of these are carried out and guaranteed, then we can say that whoever is found to have been involved in terrorist activities ought to be given the maximum penalty. By maximum penalty, I mean sentences to death, or at worst, life imprisonment. That's the minimum. Because these terrorists target lives, they target property, they target critical infrastructure. They also target destruction of the entire economy. So, I don't think the law should spare them if eventually they are found guilty, provided there is fair trial and adherence to human rights and standards.
Okay, when you look at the law itself, you've talked about the minimum and you talk about the maximum sentence as well. When talking about crimes involving terrorism, mass killing, threats to national security, should there be an option? And does pleading, guilty warrant leniency when it comes to terrorism-related crimes?
Well, it depends on the degree of participation of those who are being brought to trial. There are actually people who carry out some of these heinous, atrocities, killings, destructions of lives and properties, maiming and all that. Those people naturally would deserve the maximum penalty without leniency. But people who carry out some, logistic support, like delivering food to the terrorists, and then supplying some logistics, they are offering some logistic support. One can say that those people also needed and abetted the crime, but the deal of a meaning of the,
Well, that's the network. We'll try to reconnect back to Dr. Wahab Shittu, who is helping to make sense of today's conversation. Well, we are touching on two different issues. One is the Ansaru verdict, and the other will be the House of Representatives ordering investigation into recovered assets since Nigeria returned to democracy in 1999. Dr. Wahab Shittu, good morning to you again.
The degree of participation in the terrorist activity. Hello?
Yes, go on, sir.
So if those involved directly in this destruction, physical destruction of properties, critical infrastructure, destruction of lives, and all that, ought to be given maximum punishment. A maximum punishment can be by way of death sentence at home. But those who offer limited, logistical support, like supplying food and all kinds of, logistics, may be given, some, long-term years of imprisonment.
Doctor, so, the point is, why should that be? Because they are the ones sustaining their operations. Without logistics, there won't be.
All over the world, there are minimum. There is Terrorism Prevention Act, which is the legislation that is in place for trial and prosecution, or for prosecution and trial of terrorist offenders. And this, statutory, enactment provides penalties for categories of, offenders in the terrorist chain. Judges cannot act outside statutory framework.
They can manufacture their own punishment.
What you can agitate for is perhaps for us to amend our terrorist, Prohibition and Prevention Act in a way that will make all those who participate in terrorist activities, whether by way of accessory before or after the fact, or those who participate by aiding and abetting, including those who actually engage in the terrorist act themselves, to be given the same, measure of, punishment. That is an advocacy that we can sustain. But until the law is amended, judges have no option than to work with the statutory framework available for the trial of these offenders. And to that extent, what our judges are doing is salutary, is commendable, because you find dedicated, judicial officers being assigned to try these cases, and they are trying thousands of these defenders. Thousands of these terrorist suspects are being tried within a limited period of time, and that's why I salute the current Attorney General. In the past, some of these suspects were just lumped into detentions without trial. Some of them have been in detention for years. And you will find incidents of jailbreak, some of them escaping from detention and going back to join the terrorist network. But this Attorney General has taken the bull by the horn. He has liaised with the judiciary to ensure special courts are created and special judges are designated to try these terrorists. And then within a time frame, so these judges have to work under very tight schedules, under very tight dockets, to ensure that they deliver on the special assignment. But the concern that has also been raised is that we find out in the course of this trial that there is a regional dimension to some of these, terrorism. We find out that most of those who are perpetrating these terrorist activities are from neighboring countries, like the Niger Republic. That has come out. For instance, 2 of the 5 countries that were recently convicted were found to be citizens of the Republic of Niger. That means that beyond the judicial trial, our country must sustain national and international collaboration with our neighboring countries and international partners if we really want to combat this terrorism. It's not something that the judiciary can fight alone. It's not something that Nigeria can fight alone without collaboration with our foreign countries, including neighbor countries. We need to tighten our borders. So it's not a judicial solution that can combat this problem alone. We need to. Most of our borders are porous, very porous. We need to ensure that even when some of these sentences too are also tied with rehabilitation and reintegration, challenges. And if they are not sufficiently rehabilitated, even after serving their sentences, if they will not be properly reintegrated back into society and they go back to this crime. So I think it's a holistic solution that can solve the terrorists. It involves adequate international cooperation and collaboration, apart from the work of the judiciary. So prosecution is one way of combating it. But like I've pointed out, prosecution alone cannot solve the problem, apart from the fact that if you want maximum punishment to be given to these terrorists, which I support, then we may have to rework and re-amend our Terrorist Prevention Act in order to be able to strengthen the hands of our judges to apply maximum punishment. We also ensure that if you radicalization without rigorous and published evaluation will be of no consequence. My other concern is that the law on some of these, verdicts has not adequately reflected the interests of the victims of these terrorist activities. I think we need also to think at those who are victims, those who have lost their lives. Are the families being compensated? Those who are maimed and rendered incapacitated as a result of these terrorist activities, what kind of compensation are we making? So mass conviction without victim participation is inadequate in my view. Mass, convictions without restitution or reparations framework is also inadequate in my view. So we should also consider victims' trust fund. The government should consider institutionalizing a victim trust fund from which funds can be drawn to pay compensation and restitution or reparation to those who find themselves as victims of some of these terrorist activities. Because if you send them away to go to serve 25 years without compensating the victims of the atrocities, I think we are not doing enough in that regard, and I think the government should focus attention. So prosecution should target, again, prosecution should target not just the suppliers and the logistic suppliers, but those who are actually responsible for these atrocities, including the financiers of these atrocities. We should deploy all resources at our disposal, including technology, to fish out those who are funding some of these terrorist activities and apply the maximum punishment to them because they constitute danger to society. So just targeting the foot soldiers alone, not enough. The country's interest will be best served if the trials are both swift and they are seen to be fair, and then the maximum punishment is applied to those found guilty of the process.
Okay, Dr. Wahab, globally there is this move to remove death sentence from the judicial proceedings and all. But in a country like Nigeria, that terrorism is on the eye, how do you think the world will view this move? And also, some have also looked at the judiciary and look at the laws and say, this is even giving a second chance to terrorists. Do they deserve second chance?
Thank you very much. Crime will continue to thrive if there are no consequences for infractions. And when we're saying that consequences must be put in place to punish infractions of our laws, particularly by terrorists, then the punishment must be adequate and sufficient to deter offenders. I don't know, there's a video that is trending. I don't know whether you have had access to that video. In some countries, some of our neighboring countries, when some of these terrorists are arrested, they cut their hair, cut their legs and all that, and render them, demobilized. Those are stiff punishment. Yes, we can recommend that. Death penalty for terrorists, I think, is something that should not be negotiable. There's nothing wrong about that, because what they are doing, they don't have any regard for human lives. They don't have any regard for critical, national and international infrastructure.
Okay, looking at what you propose now, how do you think that can be framed into the
then we have to take a holistic look at the Terrorist Prevention and Provision Act, the one we have now, and see whether we can amend the punishment section in order to deliver maximum punishment for terrorists. Except we amend our laws to provide stiffer penalties, our judges cannot be blamed if they apply the law the way it is, because judges are not supposed to manufacture law. They work within the framework of the law available.
Does that seem like, judging them based on what they believe to, because there are talks about, where you have referenced that it is Sharia, once they commit such, they cut their arms, their leg, and all of that, Are you thinking in that regard?
Well, that is also some kind of punishment that we can look at. If for instance, the essence is to prevent you from committing further offenses. If you apply very lenient offenses on some of these criminals, heinous offenders, provided they are found guilty through a fair trial, I qualify it every time.
Yes.
Now, if you apply lenient offenses, the tendency of them going back to these crimes is very high. But when you demobilize them or you demarket them in such a way they are unable to take that option again, or since they eliminate their victims, they too should be eliminated. But you cannot do that except you tinker with the current statutory framework for combating terrorism in Nigeria, with the Terrorism Prevention and Prohibition Act. You understand what I'm saying? We need to amend the laws first. If we don't amend the laws, then the judges cannot be blamed for applying the law the way it is, because judges are not supposed to create law. They are supposed to interpret the law. And given the kind of results that have been achieved so far, and the dedication shown by the Attorney General and the judges of the Federal High Court who are involved in these trials, I think they deserve a lot of commendation. Nigerians as FATF, they have removed our names from FATF, green list, because the international community now is convinced that Nigeria is taking the issue of combating terrorism very seriously. Thanks to the President Ahmed Bola Ahmed Tinubu, thanks to the Attorney General of the Federation, Lateef Fagbemi, thanks to the judges of the Federal High Court who have shown commitment and capacity, and thanks to the lawyers in the Federal Ministry of Justice who are involved in the prosecution of some of these acts. We need to decongest our prisons of these suspects. And the only way to do that is to ensure that they are tried properly by adhering to fair hearing principle and then other fundamental rights standards, and applying maximum punishment for those who are found guilty, while those who are innocent should be allowed to go and enjoy their freedom.
Okay, now, still talking about that life sentence and also the possibility of this terrorist making demand, especially when they are successful with school abduction. If maximum punishment, is guaranteed, don't you think it will resolve some of this demand and school kidnapping? Because most of it is to hold governments, by their jugular to come to the negotiating table. Your say to this?
Well, I agree with you that we need to apply maximum punishment to serve as deterrence. I also believe that in a situation where terrorists hold government by the jugular, by making unrealistic demands, what they try to do is to challenge the capacity of government to deliver on law and order. Because if you look at the constitutional framework, you will see that the main reason why we have government at any level whether at the level of local government, state, or federal, is to be able to deliver on security and welfare of the people. That's the main reason why government is in place. All other issues that we look at flow from this, main obligation that government owes to citizens. So when terrorists make demands such as you have referenced of government, they are indirectly telling the government that government you are not effective. Government, by writing to their demands, will be showing efficiency, or will be showing that they don't have capacity to be able to combat. Government should not entertain such demands. That is why we have to commend the federal government for this really, rescue of the victims. And we shouldn't play politics about that. What government has done, most of those people were brought alive. And we extend sympathies to the families of those who lost their lives. But government must be commended for that feat. Some people want to underplay it. No, nobody should underplay that kind of feat. I imagine what the reactions of the people would have been if those people had died, or government was unable to rescue them. Some mischief makers will go to town to say, "Oh, this government is not responsible, it's not effective, it's not efficient." But now that government has delivered by rescuing most of those people alive, I think they ought to be commended. But beyond the rescue, I must also use the opportunity to call upon the government to ensure that those people who are rescued are fully rehabilitated in terms of compensation. Government should be concerned about their welfare. The kind of money that ought to be paid to these terrorists, which was not paid, should be paid to these victims. Some of them were young children. They faced a lot of agony throughout the detention period in the bush, in the thick forest. The school principal, imagine what she went through, and all those people were involved in the calamity. Government should think of giving them sufficient compensation. Public spirited individuals should also rise to the occasion to ensure that those people are compensated. Yeah. And we should draw lessons from what happened in Urire, abduction.
Dr. Wahab Shittu,
I'm imagining that
there is also
solution. Two quick solutions.
Okay.
Two quick solutions.
Okay.
Government should look at is to ensure that there is a permanent that we locate military barracks for these forest areas. And then we use drones to be able to detect their whereabouts. Drones, effectively. Government should look at using technology to combat some of these terrorism.
Okay, that's not said. But also know that
Dr.
Wahab.
To also
Dr. Wahab, please. Can you hear me, please? Yes, there is also a flip side to the story too, as well. When you reference the Orire, recall the governor in a state broadcast as well call for international investigation into the whole issue, the abduction and the resolution, itself. Some have said this brought about lack of trust in our institution. Let me have your reaction to it.
Well, the governor of Oyo State justifiably may have been concerned about what has happened. Every governor who is decent and humane ought to be concerned about what has the tragedy in Orire has happened. He says so. I don't blame the governor of Oyo State for being concerned about what happened. But I think the government took it too far by saying the UN should intervene. UN does not have the jurisdiction to undertake international investigation of what has happened without violating the sovereignty of Nigeria. I'm a student, I'm a lecturer of international law. I understand the doctrine of state sovereignty. Every state has sovereignty over its own affairs, domestic affairs. And no country is permitted to interfere in the domestic affairs of any state. without violating the principle of sovereignty, Indian sovereignty. I think the governor of Oyo State, for whom I have a lot of respect, may not have been properly advised about the rudiments of international law. International law does not permit the suggestion he has put forward. And that is a simple answer to that.
Okay.
And he has nothing to suggest that the government of President Ahmed Bola Tinubu is not capable. By rescuing the abducted victims, that the Tinubu government has shown capacity. And everybody must recognize and applaud that kind of move. I think the governor too should also applaud the federal government for doing that. Calling for international investigation is an indirect way of passing a vote of no confidence on the Tinubu administration. And I think that is uncharitable, that is unfair. That is, the facts on the ground does not reflect that tendency. And there's nothing to suggest that Nigeria is a failed state. Nigeria is not. I think the government of Oyo State, for whom I have a lot of respect, should work in tandem with the federal government in ensuring quality investigation is delivered and quality prosecution is offered to those who are involved in these atrocities. So his call for international investigation, with due respect to him, does not accord with the rudiments of international law.
Okay, since we are speaking internationally now, just yesterday, the United States President Donald Trump commended President Bola Ahmed Tinubu in a letter and made public yesterday in a statement by the President's Special Advisor on Information and Strategy, Bayo Ononuga, describing the President and